As with most things software, governing terms are really the sort of cornerstone of management and coordination. And so one of the core challenges for most organizations is maintaining access to those documents and the materials for pretty much any publisher. And probably whilst technology is starting to sort of play a significant part in this area, the importance of procedures and standard practices and the people that operate can't be underestimated to ensure you have an effective process that's robust and that you can rely on having that audit trail of content. I suppose the why it's important factor is that having access to all of that documentation and communication content between your organization and the publisher is typically key to aligning a number of sort of factors, but key to those are really considerations that are due between parties. And it sort of provides that framework of how transactions and other business obligations are going to be interpreted. I suppose looking back in the past, in my experience, I found many organizations tended to have a reliance on tenured staff, especially around Quest, regarding that history with the publisher. But staff do move on and their knowledge is often lost when that happens. So it's really crucial to have that sort of process and protocol in place to retain as much of that information as possible. I'll spend a couple of minutes on documentation a little bit later in the deck, but I suppose the key question I want to pose to this audience is really for you to ask yourselves, if your organization needed to access key publisher documentation, how quickly could you get your hands on that material and would it be complete? Switching over to sort of TPA and STA, Quest probably sold more products transactionally than it ever did through its master or framework agreements over the years. And these transactions, these sort of EULA terms, were very specific to the period when they were sold. Historically, they were called TPAs, or they're referred to as transactional product agreements. And I should say by EULA terms, I mean end user license agreements. Nowadays for Quest, it's called STA, or the software transaction agreement. But going back over time, those purchases, those specific end user licensing terms become very impactful as they change on a fairly regular basis. And by that, I mean, in some cases, they would be changed a couple of times a year, in some cases, at least once every year. And licenses purchased under those transactional arrangements are governed by the terms of that particular year and month when it was transacted, which most certainly are going to be very different from the T's and C's that govern Quest products today under the current STA terms. And you've got to think about it this way. It's the current T's and C's that a Quest compliance team would prefer to rely on when and if they knock on your door to audit your company. I've highlighted the sort of next sort of bullet is know your terms, know your usage terms and obligations. Probably the most important highlight on this slide across all of the bullets, it's relevant to every publisher that you work with, is really to know inside and out what your organization's responsibilities and obligations are in terms of utilizing and managing the publisher's software and that license grant that is being shared with your company, whether that's on-premise or cloud subscription-based licensing. The publisher is only really providing your organization with the right to use their intellectual property. In the case or in the situation where your organization should misstep, ignorance is typically not deemed to be a great excuse in terms of contract law, and it's not really going to hold you in good stead if your company is caught breaching a publisher's software agreements. So whether it's geographical restrictions, technical factors, or any other issue, to be fair, that's relevant to that publisher's EULA, you want to have the confidence that the people supporting the Quest products and the portfolio that you're operating know these elements in fine detail, and that process and management oversight are really aligned to sort of mitigate those risks moving forward. Product owners are something I'm also going to touch on a little bit later in the deck, but again, because of the alignment between product owners and governance is really so important, I did want to sort of put a little sort of comment here on this particular slide. And whether your company and organization have procurement, vendor managers, IT category managers, IT product and app owners or not, they may have a combination of some, or in some cases, they may not have any. Either way, it can't be underestimated as to the value of having that deep subject matter expertise within your organization supporting that particular publisher. And obviously today we're talking Quest, but that's the same pretty much for any publisher. These experts are really going to drive the day-to-day operational use of the software solutions and to coordinate and manage the publisher relationship. And it's those individuals that really know the publisher and the technologies that will act as the safety mechanism that's really protecting your company in terms of mitigating those risks, but also maximizing the value you're receiving for your budget dollars. And I suppose as subject matter experts, they're going to play a key role in how your company looks to plan and strategize for the future. Technology doesn't stand still, technology changes. And so too, I suppose, to that end is how organizations engage with a subject publisher. And again, that's probably something we'll get into a little bit later. I couldn't really sort of look at contractual governance and not really think about M&A and the impacts that has. It's an element that is commonly overlooked, or maybe I probably better say that maybe it's a little bit underestimated, as M&As can really play a significant part of introducing risk to a business. M&As typically constitute a compliance bag for pretty much any software publisher, and that's going to increase the risk of an audit. So that's always a factor to consider for the organization, and obviously being prepared. When taking on or divesting a company, the challenges that come from integration, the contractual obligations that align to M&A, things like licensing sprawl and a host of other elements that sort of go on are either forgotten, ignored, or pushed to the back burner as other things take priority. But it's those things that can really come back to bite when the software publisher comes knocking on the door, highlighting that compliance or contractual terms have not been appropriately addressed and managed. And typically, while in most cases lawyers who are supporting the M&A transactions will put warranties in place in the legal paper to overcome some of those information gaps or lack or issues with due diligence, the pain of dealing with the publisher compliance or commercial teams is going to fall on others, and that can have pretty serious consequences. Making sure that you have that expertise and the support to coordinate the M&A phase and to manage that sort of software asset management concern, it can't be underestimated. In the bigger scheme of things, I suppose software charges can appear immaterial to the billions of dollars that are changing hands when buying and selling big business. But if you go and ask the CIO or the procurement team of an impact on a 6 or a 7 or even an 8-digit compliance issue arising off the back of an M&A, or the IT group managing multiple audit requests, it's not an insignificant burden that these teams have to face, and they'll be facing it far, far earlier than anything that is going to come from legal warranties that may be in place. So I suppose if in any doubt, especially around M&A, reaching out to an expert consulting firm who support these issues is definitely something to be considered in what is really becoming an increasingly more relevant activity year over year as more consolidations happen across industries, and where software is becoming a much more central tenant to every organization's everyday business use and need. Which is probably a good segue in terms of the next topic, which is managing change. And again, it's framed within contractual governance. So change is a constant in business, and certainly in the world of IT and software, the speed of that change is pretty rapid and comes with significant consequences to the business world if and when things go wrong. And businesses need to be adaptive to change in whatever form it comes. And we probably see that most readily as what's happened this year. As your business changes, which it will, ensuring that you have the right people in place to help evaluate the technology and the corresponding contract needs, it's certainly going to enable your organization to be proactive for both its short and medium term, but also its long-term strategies for publishers, be that Quest or any other publisher for that matter. And whether it comes from M&A, market forces as we see today, technology product review boards that you may be looking to sort of follow, Managing change is always going to require that organizations evaluate and reevaluate and potentially realign their contractual governance and the terms that suit. Hence, we made contractual governance the first pillar we wanted to cover today.